This is the Alex Medina Law Podcast. Practical insights into the world of civil litigation.
So what would you say the top mistakes that most lawyers make are?
So much of what we do is a chess match. You have to think in litigation about just because you can make an argument doesn't mean that you should. And once you say something in a brief or in court, you can't take it back. And so we always have to be thinking as lawyers about, if I do this, what will the other side do? Then what will I do? And 5 steps ahead. And so that's part of the whole process, is when a client or a potential client comes in and says that's the problem, you need to sit with it. You need to research it. You need to look at all the angles. You need to figure out what the law is. You need to find out what the facts are. You need to meld the two and figure out how they work together. And then you got to think strategy. What are the best arguments to make at this point in the case? What are some that we should save until later? What are some that are really good arguments, but if we do them, it could lead to a chain of events that wouldn't be to the ultimate benefit of your client. And I think a lot of litigators, and this could be another mistake, is a lot of litigators want to win for the sake of winning because there is a rush in it. I don't think that you get into litigation by accident. I think it is a personality type that enjoys the competition, enjoys that adrenaline rush that you get, that enjoys kind of the dialogue and the debate that goes into the process. And I have known plenty of litigators who have made grave tactical blunders because they wanted to win a point for the sake of winning, and they didn't think about the bigger picture of what are we really trying to accomplish here. And to build on that point, I think if we could focus on another mistake, it's, again, to use a trite or cliched phrase, not being able to see the forest for the trees. Because the ultimate goal in a litigation case is to bring your client justice, is to bring about an end to the dispute. And this might be different from what other litigators would say, which is to win. I don't think that's always the case, because at what cost? You can go and scorch the earth and spend tens and hundreds of thousands of dollars, get all the way to trial, and you've won. But then what have you really won? What's the actual cost? There are certain cases where that's necessary. But I think that given the cost of legal services these days, and I don't just mean financial costs, of which they are very high, but I mean the emotional toll, the emotional cost, the time cost, all those things that play together. I really do believe that if a case goes to trial, that there has been a failure that has happened, because it's so expensive in terms of time, money, emotions, everything, that there should be a way to work out a dispute without having to go to trial. And I think for the most part, the profession does a good job of it. I don't know the exact statistics, but it is a small fraction of cases that actually go to trial. But I think that if more litigators spent the time to really think through the end game, what is the best result for my client in this case, and how do we get there? And if that's the mantra that lawyer thinks in his or her mind every single day they go to work, what can I do on this case? What in this email response, what in this letter, what in this brief best gets us to that goal? Brings us a step closer to a resolution that doesn't require a long, drawn-out, expensive, stressful trial. I think that the clients and the lawyers would be much better served than, I've got this argument, how do I beat it?
Thanks for listening to the Alex Medina Law Podcast. Check back often for new episodes and follow along at alexmedinalaw.com.